share my. Okay, wonderful. Give me 1 second while we get set up. I appreciate everyone's patience. And we're going to go into presentation. Give me 1 second. Okay. So thank you everyone for joining us today. As you know, we are presenting today on ADA's compliance for small businesses. Today's presenters include Mar Harris. She's a wonderful staff attorney on the small business development team, and myself, Carla Jacobo. I am a paralegal. You can see our contact information listed on the screen. We will go ahead and share this information with everyone in attendance today, and I really appreciate you taking the time for joining us today. We will cover quite a few things today, so if you find that the presentation is going a bit too quick, please go ahead and just say, hey, can you repeat that? Can you slow down? We're really interested in getting you all connected to great information and supportive services as much as we can. So we will go ahead and cover how to connect with Tzedek, a little bit about our program, and then we'll go ahead into the substantive conversation about ADA compliance. You will see that throughout today's presentation, it will be myself and my colleague Mar Harris doing a lot of the conversation. But we also have our director joining us. Her name is Nadia Segura. She is also available and may participate in the question and answer portion towards the end of today's presentation. So thank you so much to everyone joining us today. We will have folks joining us throughout the presentation, and we really look forward to being able to answer any questions that come as the presentation continues. So let's go ahead and start chatting a bit about Tzedek, our legal services and our overview. So Tzedek is a nonprofit legal services agency with over 40 years of history. We provide free legal services to folks in the Los Angeles County area in a variety of areas, and we provide services regardless of an individual's race, religion, ethnicity, or immigration status. Today we'll talk about our small business development project just a little bit right before we get into our ADA compliance presentation. So the small business project, we are designed to assist low to moderate income entrepreneurs secure free assistance with a wide range of transactional business law matters. And we do this in a variety of ways. So what we are all participating in now is one of the vehicles in which we go ahead and communicate with folks, which is through community presentations and workshops, small business legal academies, which is a combination of a presentation and an opportunity to connect with an attorney to receive a one-on-one consultation. If that attorney cannot resolve the question that you have regarding your small business at that time, then they let us know and we follow up with you. We also provide a variety of guides and other free resources that are available on our website and that can also be provided through our application process. And if folks qualify, we also offer direct client representation in a wide variety of transactional and negotiation matters. We do have a great structure that's built to support small businesses so that small business owners and small businesses can secure effective free legal services in a variety of matters. So what you see on the screen right now are a variety of services that we assist with, right? Intellectual property matters, business entity, contracts, bankruptcy, employment law, just to name a few. And the details of all of those can all be provided once you connect with our team through our application process. In our application process, we conduct an eligibility screening to see whether folks are eligible for direct representation, and that eligibility screening includes an assessment of a household income, eligibility threshold, business profits and sales are factor in as well. We do focus on assisting for-profit businesses in Los Angeles County. So what that means is that at this time, we do not provide direct services to nonprofits, but we do have some great referrals to agencies that may be able to assist. So when in doubt, just connect with us and we can go ahead and connect you to those agencies by providing you those referrals. And we do stress that we assist in transactional, not litigation services. Lastly, we do love to communicate to everyone that all of our services can be provided in different languages through staff or a language line, and accommodations will always be provided for clients with disabilities. Accessing and connecting with us is a priority on our team. How to get help? So I apologize for that. So the free resources, you can always connect with us through our website, and you can also complete an application for assistance. We will go ahead and share these links with you once we distribute a recording of today's training. So you'll have an opportunity to connect with us if you have not connected with us before, or if in the future you're currently working with us, but then want to fill out an application for some services and want to return, you're more than welcome to do that as well. We do want to go ahead and let everyone know as we transition into the ADA presentation, the following. The following information is intended to assist in spotting legal issues relevant to small businesses in the state of California. Many factors must be considered in determining which actions and decisions would be most appropriate for any specific situation. This presentation only discusses some of the more critical factors. It is not intended to substitute for legal advice. After discussing it thoroughly with an attorney, you should decide which is the best course of action. So this slide really communicates that what we are providing today is primarily legal information and not legal advice. If you are seeking legal advice, please connect with an attorney so that you can decide the best course of action. So now moving into our overview for the ADA presentation. So these big areas are what we're actually going to be working through in the next hour or so. So first, we will go ahead and chat a bit about an overview of the Americans with Disabilities Act. Second, we will go ahead and explore how to respond to an ADA lawsuit. And lastly, getting connected to legal services. So while we provided some information on how to connect exclusively to the Tzedek Small Business Development Team a few minutes ago, we also want to provide information on how to connect to additional legal services that come into play once we have small businesses or businesses that are now encountering a suit related to an ADA non-compliance. So let's go ahead and get into it. So what is the Americans with Disabilities Act? It is a federal civil rights law that protects people with disability, and this includes prohibiting the exclusion of people with disabilities from everyday activities like shopping at a local business. To meet the goals of the ADA, the federal government has issued requirements, the 2010 Americans with Disability Act standards for for-profit and nonprofit private businesses of all sizes. So all of our small businesses are the American Disabilities Act applies to all of our for-profit and nonprofit businesses. So if you're a small business owner, then we are engaging with the possibility of having to be held liable for a non-compliance. So the American with Disabilities Act, what does it mean? So under the ADA, a disability means having a physical or mental impairment that substantially limits one or more major life activities, such as personal care, performing manual tasks. It also means that that individual has a record of such an impairment or such a condition or remission. And also, they are being regarded as having such an impairment, meaning that that person, such as a person with severe burns but no impairment. So these are all definitions that are found under the ADA, and they are applicable. I'm sorry, I went a couple of slides ahead, and they are currently applicable under the Act. So we'll go ahead and talk a bit about how this Act then is applied in the state of California. So two California statutes, the Unruh Act and the California Disabled Persons Act, incorporate the ADA, which is a federal statute, into the California civil rights law, allowing people with disabilities to sue violating businesses to recover monetary damages. The Unruh Act provides for statutory damages of $4,000 per offense, and the California Disabled Person Act provides for statutory damages of $1,000 per offense. So these two statutes are the ones that also apply to the state of California. In contrast, the Title III of the ADA, meaning at the federal level, only provides for injunctive relief, meaning that they could only bring a lawsuit against a violating business to compel them, meaning to ask them, to force them to comply with the ADA instead of having to pay monetary damages. In this way, the state of California expands the scope of the federal ADA. Okay. The ADA establishes requirements for public accommodations, meaning businesses that provide goods or services to the public. There are 12 categories of public accommodations. These include anything from stores to restaurants, bars, service establishment, theaters, and all of the other locations that you see on your screen. It is important to note that businesses that fall within the 12 categories listed on your screen are subject to the requirements of the American Disabilities Act, regardless of the size of the business or the age of their building. Also, commercial facilities that do not provide goods or services directly to the public, so things such as office buildings, factories, or warehouses, are only subject to the American Disabilities Act requirement if they make alterations or undergo new construction to their facilities. So there is a difference between the commercial facilities and then the business that are actually listed as one of these 12 categories on your screen. We're going to chat a bit about reasonable modifications. So reasonable modifications under the ADA. To accommodate people with disabilities, your business may be required to make reasonable modifications to its rules or policies. So anything that would result in a fundamental alteration, a change is essential to the nature of your business, is not required. So let's talk about what this means then in the day-to-day. So we have a definition here, but what does that mean? So for example, a restaurant is not required to prepare a unique dish for customers that have disabilities, because this would be a fundamental alteration of the restaurant services. However, if it is easy to not include a sauce or an ingredient from a dish that's listed on the menu, a customer can request that item, that sauce, that food item be not included in their dish. This would not be considered a fundamental alteration. Okay, let's go ahead and chat a bit more about this. Another example, a reasonable modification. A daycare center must allow a child with diabetes to have an extra snack. And then lastly, another example, just to get a bit of a better idea of what a reasonable modification is if you're in a clothing store, right? A clothing store must allow 2 people in a dressing room if a person with a disability requires a companion. However, the clothing store does not have to provide dressing assistance if it does not offer that service to other customers. So there are different ways that a reasonable modification can be offered by small businesses, but it just looks a bit different based on the type of services that that particular small business offers. So now let's chat a bit about the types of assistance that different businesses can offer customers. So customers with disabilities may need different types of assistance to access your goods and services, right? So examples of this, retrieving merchandise from high shelves, right? Accessing stuff that is too high, assistance in navigating the aisles of the store, making sure that they can make their way through your store or your small business or your business with ease, or assistance in reading the product labels and instructions. So those types of different assistance to access your goods and services often require different levels of communication. So let's chat about what that looks like when you communicate with your customers in getting those points of access going, right? Communicating with your customers. So businesses must take necessary steps to communicate effectively with customers that have vision, hearing, and speech disabilities. The method of communication will vary on the abilities of the customers and the complexity of the communications that are required. Now, every situation is different, and every small business and every business can and must make an effort to effectively communicate. So I would like to just introduce a couple of examples of what this looks like. So a sales clerk, if they have a customer who is deaf, and that sales clerk maybe is not well versed in sign language, they may exchange written notes with the person who is deaf so that they can communicate effectively with that customer and really create an opportunity to connect with that customer and address their needs or assess whatever question that they may have. Whereas in a situation where we have an individual who has a hearing, or vision, or speech disability, and they are discussing cancer treatments, they're in a medical setting where they have to discuss cancer treatments, a sign language or oral interpreter may be necessary in order to effectively communicate, given the nature of that communication. So in different scenarios and in different settings, there must be efforts. The business must take steps necessary to effectively communicate. How are those channels of communication going to be open? How is that connection with that customer that's experiencing this disability? How are they going to receive their services? Okay, so let's go ahead and transition as we move forward with the customer experience at the business. Oftentimes, as you may know, we actually have service animals, right? There are these furry friends who are trained and certified to be able to support individuals who have disabilities. So let's chat a bit about what this looks like. So a blanket policy disallowing pets from entering an establishment may run afoul of the ADA concerning persons with disability who rely on service animals for support. A service animal is a dog individually trained to work or perform tasks for an individual with a disability. Comfort, therapy, or emotional support animals are not service animals under the ADA. So in this arena of, well, how do we create policies that are in line with our business but still allow us to carry out our day-to-day operations and still allow us to be compliant with the ADA. We do have some information that we do want to provide as you consider making your policies for your business. So a business may actually exclude service animals only if the dog is out of control, the handler cannot or does not regain control of said animal, and the dog is not housebroken. In the event that a service animal is excluded, the individual must be allowed to enter the business without the service animal. Now, if you have a question about whether the dog is a service animal or not, a business is allowed to ask two questions. One, is the animal required because of a disability? And two, what work or task has the animal been trained to perform? So we have those considerations when we think about the service animals that are accompanying our customers as they experience and have access to a variety of businesses. Okay. So now we're going to transition into talking about wheelchair and other mobility devices. So it's important to note that businesses cannot prevent people with disability from using mobility devices in all areas customer visits. So there is a focus on allowing folks to be able to navigate your business in the way that everyone else navigates your business. And what does this look like, right? This may include allowing customers with mobility devices such as segways, golf carts, depending on the establishment's ability to reasonably accommodate those mobility devices, right? Depending on the mobility device size, weight, dimension, speed, and other safety concerns. Public accommodations must also allow entrance to their premises unless the business can demonstrate a legitimate safety requirement compelling otherwise, right? Not speculation or stereotypes. So it's really important to be able to work through legitimate safety concerns and highlight those if for some reason you're having to make accommodations to the entrance. It's also important to note that businesses may ask individuals using an alternative mobility device, such as a Segway or golf cart, for credible assurance that that device is required because of a disability. Such reasonable assurance can include a disability placard or a verbal affirmation. It is also important to note that, while you can ask a couple of questions to see either the disability placard or verbal affirmation, a business should not pry into the nature of the customer's disability, right? So we can't go beyond asking just a couple of questions to get that assurance. If you have a doubt about what types of conversation and what is valid when asking customers about their disabilities, please connect with us, connect with the lawyer, have that conversation with the lawyer so that you're not going beyond what is allowed under the ADA when you are requesting an assurance, right? It's always about creating great communication and allowing all customers to feel supported as they navigate your business and as they have access to the customer experience at your business. Okay, so we're moving forward. Let's chat a bit about that customer experience, right? We have folks who are visiting your brick and mortar. We'll talk about online websites later on in the presentation. But here, right, we are discussing what it looks like, what's the physical experience, the auditory experience of experiencing your business. And oftentimes, right, structural architectural barriers are part of your business, right? So they are physical features that limit or prevent people with disabilities from obtaining the goods or services offered. They can include parking spaces, entrance steps, doors handles, narrow aisles, high counters, and fixed tables. The ADA requires that small businesses remove, meaning take away, no longer make available, architectural barriers in existing facilities when it is readily achievable. So now let's talk about what readily achievable looks like. It means that it is something that can be easily accomplished without much difficulty or expense. And this requirement is based on the size and resources of the business, as well as broader trends when there's an economic downturn, right? With the COVID pandemic, we all experienced an economic downturn. All of businesses were impacted in different ways, right? So all of those things, right? Just the most recent example, all of those things are considered when determining what's readily achievable. It is also important to know, we would like to communicate, right, that the ADA standards for accessible design, it's a resource that can help determine when the removal of an architectural barrier may be required. And I'd like to give you a bit more information of what's included. So when a business removes barriers, it should be allowed to follow the design requirements for a new construction in the ADA standards accessible design. What that means is, right, the ADA standards, remember we mentioned them earlier when we were talking about California and the expanded scope and how we determine what is reasonable or not, right? Those standards get updated from time to time. And as they get updated, right, in some cases, some existing conditions or limited resources or both factors are considered to impact whether something is readily achievable to comply with the standard. So if this does happen, there are instances where you may be able to argue as to why this update may not be required. But if you have that question, it's important to consult with an attorney so you can figure out whether it is applicable to you. Okay. So let's just go ahead and chat a bit about, okay, so we know a little bit about the architectural barriers. We know a bit more about what's readily achievable and what does this mean? So how do you prioritize, right? I have all of this information. How do I apply it? So right now, what we can communicate is that the ADA regulations recommend the following priorities for barrier removal, meaning when you're thinking about your business, when you're looking at your physical space, what is at the top of your list, right? So this is some information that we recommend to be priorities, meaning the top of your list. So providing access to your business from a public sidewalk, parking areas, and public transportation. Providing access to the goods and services your business offers. Providing access to public restrooms and removing barriers to other amenities offered to the public, such as drinking fountains. Remember, we're talking about the customer experience, navigating through your business. If you're providing goods and services, how can someone who has a disability based on, right, all of the information that we explored earlier in the presentation, how are they going to experience it? How are they going to navigate? Can they get in through the doors? Can they walk through these aisles? Can they navigate these spaces? Can they communicate with your staff? How do they experience that? Okay. In talking about accessibility and that customer experience, right? This is when we're talking about that physicality, right? Let's chat about entrances. Most businesses have entrances so that they can access goods and services, right? So where even a single step prevents people with disabilities from entering your business, installing a ramp or a lift or regarding the walkway can provide an accessible route. If the main entrance cannot be made accessible, an alternate accessible entrance can also be used, right? So we talk about what this physical experience is, navigating the experience as a customer, right? So here we're talking about a single step. Let's go ahead and install a ramp. Let's talk about ways that we can allow folks to access your business. If it can't be that one that folks can walk through, then let's go ahead and create an alternate path. You build along the way, and I think creative measures here allow for an opportunity to really be compliant and to have an opportunity to give yourself the best chance to be in compliance and reduce instances of allegations of non-compliance. So let's chat a bit more about this point, right? It seems to be the one that we encounter visibly the most as customers as we walk along. So, accessible routes to goods and services, right? The path a person with disability takes to enter and move through your business is called an accessible route. This route, which must be at least 3 feet wide, must remain accessible and not blocked by items such as a vending machine, ice machines, newspaper dispensers, furniture, or filing cabinets, right? Again, put yourself in the experience of the customer. Can they have access? Is it less strenuous, right? In whatever mobile device that they are using. Are you directly contributing to keeping that space free and clear from anything that might prevent them from entering your business? Meaning, are you making this accessible, right? Let's talk about the shelves in your counter in your physical, your brick and mortar, your business. Shelves and counters must be accessible on an accessible route with enough space to allow customers to use mobility devices to access merchandise, right? So you have a customer that's on a mobility device. It's very important to think about they've now made it through your door. What is their experience when they're navigating through your aisles, getting access to your goods and services? What does that look like? So it's important to note that where barriers prevent access to these areas, they must be removed if readily achievable. However, businesses are not required to take any steps that would result in a significant loss of selling space. If you think that you are in that arena where you might have a significant loss of selling space, please consult with an attorney. People with disabilities must access table, food service lines, and condiment beverage bars in restaurants, bars, and other establishments where food and drink are sold. That's very important to know. Again, we're creating an experience that's equal to all persons, regardless of whether they have a disability or not. As we continue to talk about this lived experience, right? Parking is a practice of everyday life for many of us, right? And this impacts your businesses. If you have a physical space, more often than not, you have to deal with issues of parking. Issues of parking as they apply to folks who have a disability look like this. Businesses must provide accessible parking spaces for cars and vans that are readily achievable. One of every 6 spaces must be van accessible. Small businesses with 4 or fewer spaces must have one accessible parking space, but no signage is required. An accessible parking space must have an access aisle to allow a person using a wheelchair or other mobility device to get in and out of a car or a van. So that's very important to know, right? When you think about creating your parking layout and thinking about accessibility, right? Make sure that you're compliant because, parking and having an opportunity to leave your vehicle to then enter your physical space, it's a very big experience. It's a common experience, and it's one that small business owners and businesses are responsible for orchestrating to allow folks to visit and get access to your goods and services. So we did want to chat a bit about the state building code because, all of this is related to layout, to accessibility, what this looks like. So we do want to note that building inspectors will check whether the renovations covered by your building permit meet the accessibility requirements under the building code. However, your business location must comply with the ADA barrier removal requirements. So all of these need to take into consideration when you are making any improvements, either during construction, renovation, under a new building permit to your business. All newly renovated areas must meet the accessibility standards, and the businesses may also be required to ensure accessibility of the building's main entrance, the route to renovated areas, bathrooms, drinking fountains, signs, or serving of the renovated area. If the cost of construction is under state valuation, it changes every year. You can limit the cost of accessibility improvements outside of the area to remodel to 20% of overall construction costs. Again, when in doubt, please go ahead and connect with an attorney to consult about your specific issue. We understand that all businesses have different needs and different setups. So when in doubt, it's important to connect with folks that can give you some guidance as to how to move forward. So our next topic is chatting a bit about new construction and alterations. This is when my wonderful colleague, Mar Harris, will guide us through the remainder of our presentation this afternoon. I do see that we have an item in the chat. If it is a question, as I mentioned, we will have some minutes towards the end of the presentation to review and answer if we have a specific answer. If not, we'll give some resources as to how to move forward. So Mar, thank you so much. I will allow you to take it away.
Thank you. Hello, everyone. I am Mar Harris. I'm one of the staff attorneys with Tzedek. And this next section, we will discuss new construction and alterations to existing buildings, which my colleague Carla previously discussed. So with ADA compliance, it does apply to new businesses and facilities. So when you're making alterations or you're building a new facility for your business, you must make sure that the alterations or the new facility is compliant with ADA rules. So alterations, as you can see, to a construction building or a site include remodeling, renovating, rehabilitation, reconstructing, or changing or rearranging structural parts of the building. So when this happens, to mitigate your liability with regards to non-compliance with ADA, it is recommended, highly recommended, we'll go to the next slide, please, that you hire a state building or a certified access specialist to inspect the building. And something that will assist small business owners is tax credits and deductions that the IRS allows businesses to apply for in order to comply with the ADA and state rules. So Section 44 of the IRS code allows for a tax credit for small businesses, and Section 190 of the IRS tax code allows for a tax deduction for all businesses. I'll go more into the certified access specialist, but a little more on the tax credit. Tax credits are available to businesses that have a total revenue of $1 million or less in the previous tax year, or if they have fewer than 30 full-time employees. This credit can cover 50% of the expenditure cost in 1 year, up to $10,000 to renovate or add alterations to a building in existence to comply with ADA. And so the minimum or the maximum tax deduction that is available to all businesses under the IRS code is $15,000 per year, which can be really helpful to small business owners. And then we'll go to the next slide. So in order to mitigate liability for non-compliance with ADA under federal and state, we'll go back to the CSP access. Thank you. So you can hire a certified access specialist. They will come to your site and they will provide you with a written evaluation that tells you what needs to be improved in order for you to be in compliance with the state and federal disability laws. And when you get this report done, as we'll see later, it provides certain protections for you if you are presented with a complaint or an ADA violation under federal state rules. So this is something that you highly want to consider having done to your site. It will help you later on, and the cost maybe you will find may be worth it. So please, let's go to the next one. For existing buildings that were in existence, I would say prior to 1991, and also complied with the requirements of the 1991 Safe Harbor Acts and later the 2010 for modifications, you are provided with certain, I would say, with safety from non-compliance, and it could potentially reduce the amount of money that you would be liable for if there is a suit filed against you in federal or state court. So if you are in compliance with the 1991 standards and your building was altered or constructed prior to 1991, then you're able to follow those standards and you're not liable for the 2010 standards that came later for small business owners. However, if you make any alterations or changes that affect compliance with the 1991 standards, and the Safe Harbor Act no longer applies to your 1991 building, and then you would be subject to the newer requirements, and you would have to follow those, or you would be in non-compliance and potentially eligible to be sued. So we'll go to the next slide, please. One of the things that we've noticed in our small business development program with our viewing of commercial lease agreements, many of you may encounter this during your time as a small business owner if you have a brick and mortar, but you want to make sure that you read the lease agreement and specifically check for clauses that address ADA. You want to ensure that, especially in California, you want to see if the lease addresses whether or not the landlord or the tenant is liable for the ongoing costs of ADA compliance or improvements or alterations that may be needed to your new construction site. Again, if your building is under the 1991 codes, then you're able to follow those. The moment you start making alterations, then you are liable for the newer requirements. So when in doubt, it's highly recommended that you have an attorney review your lease agreement. And with our department, we assist small business owners with commercial leases and reviewing them and negotiating them on your behalf. So if there is a clause in there that requires you to make sure that the building and the outside spaces are in compliance with state and federal ADA laws, then it's highly recommended that you negotiate these particular clauses. And this is something, again, that we would be able to assist you with if you were to sign up with our program, so that your liability for, I would say, altering or improving these areas of the brick and mortar that may not be in compliance are passed on to the landlord. And my colleague Carla is also doing a research project just to make sure that passing this liability onto the tenant doesn't violate public policy or the intent of the laws that are here to protect people with disabilities. So the best practice, again, is to make sure you thoroughly read the lease. And if you are in doubt, have an attorney review it. And if you can, negotiate with the landlord to limit whatever liability you have. And again, this is something that we can assist you with if you are eligible for our program. So thank you. And let's go on to the next slide, please. So next is online accessibility. Many of you who have small businesses could potentially have, I would say, a business website that offers your goods or services to the public, or you may have social media websites that outline your services and again, offers said services to the public. And this is where ADA laws come into play. You will need to make sure that your website is compliant with ADA rules and regulations. So this liability is placed on both the web host and the person who owns the website. So even though it would make sense that the web host would have built-in measures to ensure that the website is in compliance with ADA, you can't rely on that. And you may have to pay additional funds to an outside company to make sure that your website or your social media accounts are compliant. So although the Department of Justice, who handles this particular regulation, and also the state, they don't have specific requirements, but the ADA generally requires that if there are videos and images on the website, that the video or images have descriptions that are available for people who have vision impairments. And also you may have to have captions, or the captions may have to be available verbally for those who are, again, are low vision or who can't see the particular video or images. And then you may also be required, if you have webinars like the one that we have now, or presentations, they should be available in PDF form for those who have low vision or who are using assistive technology device. So it's highly recommended to be in compliance with federal and state regulations to have webinars and classes such as this available in PDF forms. So the next part, which we'll discuss, is how to respond to a lawsuit, specifically in California. We've seen in California an uptick of individuals suing small business owners for, I would say, non-compliance in their brick and mortar or even on the websites, and because it's much easier to file a lawsuit in California, and I'll get into that. So there is a method for responding to a lawsuit in California. So this is, as you can see, we have an ADA lawsuit process table of contents. We'll go over a demand letter versus a complaint, which you may receive either in California. We'll go over damages and liability, when and how to hire an attorney, how to evaluate claims should you receive a demand letter or a complaint, which would affect how you respond to either. We'll discuss possible defenses. There are certain, situations wherein the amount that you are potentially sued for may be reduced but not completely waived. And next, or lastly, we'll discuss potential resources for state and federal claims. So let's go to the next slide. When you have a brick and mortar, you're available to the public. So there are individuals who will come in and out of your business on a daily basis. Some of those individuals may have a disability. You may or may not be able to determine what the disability is, as some are visible and others are not. And you want to make sure that you are in compliance, which is why we discuss having a certified specialist come and inspect your site and provide you with a written report, because as we can see later in this particular portion of the presentation, this will come into play later and it could limit your damages. So when you receive a demand letter, this is basically a letter that outlines the moving party's claims that you are in violation with ADA compliance. This demand letter is a sign that they haven't necessarily filed a lawsuit in court yet, So this is an opportunity for you to evaluate the claims. And if you have a CSP report, you have a certain amount of time that you can fix whatever violations are alleged, and then your liability amount would be reduced, as opposed to if you didn't have the report, then you would be liable for a minimum full amount that someone in California can sue you for. So again, the demand letter is I would say notification from a moving party that they're claiming you were in violation of something within the ADA statutes or rules. They haven't filed a lawsuit yet, and potentially they want to settle with you. And if you settle with this person, it's highly recommended that you obviously reduce the settlement to writing, and that you do fix the particular issues that they're alleging, because you can still be sued later from another person coming into your brick and mortar, even though you've settled it with this particular person. So while you're not required to respond to a demand letter, you should, and you should try to negotiate a settlement with this person or entity. And if you don't feel comfortable, then it's highly recommended that you reach out to legal counsel. And as I mentioned previously, we are able to assist small business owners within our program if you're eligible with responding to these sort of demands. So we'll go to the next slide, which discusses steps to take if you receive a demand letter. So a person may have come in, you're unaware, you may not be aware that you have violations, your counter may be too high for a person with a wheelchair, your aisles aren't wide enough for someone to navigate that area like someone who doesn't have disability and see your goods, or there may be an impediment to the entrance. There's a step and no ramp, so they're not able to actually physically enter your store. So when you receive a demand letter, you want to check to see if time is of the essence. Is there a deadline? If there is, you may want to ask for an extension so that you can reach out to counsels and receive assistance with responding to this demand letter. So first, you can either respond on your own, or you may, as we highly suggest, consider hiring legal representation or an attorney to respond on your behalf. You or the attorney should evaluate the claim. If you have a CSP report, it may be a lot easier. If not, it may be more difficult because you're not an expert and you may not be able to tell if there is a valid claim. Then you want to respond to the demand letter, or the attorney will respond on your behalf. You can propose a settlement. If a settlement is reached, then you want to reduce it to writing, meaning create a contract that you and the other party sign that also includes what is called a 1542 waiver in California, which would prevent them from suing you for other instances they weren't aware of at the time that they signed the settlement. So even if they sign a settlement and there's no 1542 waiver, which is required by California, maybe they didn't mention all of the particular violations. They can come back and say, hey, there's this other violation that I didn't mention in this settlement, so I'm going to sue you for that. So it's very important to have a solid settlement agreement that is drafted and or reviewed by an attorney. So the next thing we'll discuss in the next slide is a summons and complaint, which is separate and different from a demand letter, because this means that the moving party or the plaintiff has actually filed a lawsuit in court, which means you are required to respond within a certain amount of time. If it's filed in the state of California, under state laws, and you have 30 days to respond. If it's filed under federal court, then you have 21 days. So when you receive a summons and complaint from the court, if you do not respond, they could potentially win by default, and whatever they're alleging and the damages they're requesting, including a minimum amount per violation plus attorney's fees, will go to them. And this could have devastating financial effects on your business. So again, when you receive a summons and complaint, that means someone has decided to sue you in court. They don't have to give you a demand letter first or notification that they're going to sue. It's not required. They can just file a lawsuit in court. So, and the lawsuit will describe what the violations are and details of the case against you. And so we'll go into the next slide, which is how to respond if you do receive a summons and complaint. So a summons and complaint is filed with the court. So the next step is the person who's filed this claim has to serve you. And if they don't serve you, then the lawsuit won't go forward, but they have a long amount of time to serve you. So if you receive a lawsuit, they'll serve you in person or an agent in your store who's over 18 and who's over 18. So once you receive this summons and complaint, it's highly recommended that you reach out to an attorney as soon as possible, because at this point, time is of the essence. And you want to evaluate the claims, and if you hire an attorney, they'll evaluate the claims and potential defenses. They'll determine whether or not you're eligible for a stay of proceedings or an early evaluation conference, which we'll go into later. And that again is tied to the CASP report that you would have had written on your behalf when you first had the building constructed or made alterations or even took over a commercial space via a commercial lease. So if you are eligible, then you or your attorney will apply for a stay of proceedings and early evaluation conference within 30 days of receipt of the lawsuit. And then you can still attempt to reach a settlement. If you're not eligible because you don't have a CASP report and there aren't any other safe harbor or anything else that would limit your liability or potentially the lawsuit itself, then you'll file an answer if it's California within 30 days. And then you can also optionally apply for a mandatory evaluation conference. And then always you can try to reach a settlement, even if there's a lawsuit filed. And if a settlement is reached, then the lawsuit can be removed from court essentially. And then you would still want to get it in writing and make those improvements so someone else can't come to your building and sue you. So we'll go into the next slide, which describes damages versus liability. So if your brick and mortar space or your business website is not in compliance with the ADA rules or laws and the equivalent under California law, then you will be liable for a lawsuit. And it's probably a matter of time before you would receive a demand letter or complaint in this state. And especially in this county, as I've mentioned before, we've seen an uptick in this type of lawsuit because it can be profitable to a person who has an actual disability. And whereas in other areas of law, it may be frowned upon if you're litigious, meaning you file a lot of lawsuits. In this particular area of law, because the state and the federal government has an incentive to protect persons with disabilities in public accommodations, there is no limit. There are people who filed 300 and counting lawsuits, and they make a lot of money, and they'll get a minimum fee and attorney's fees if they're successful in each case. So in California, a person can file a lawsuit and receive a minimum of $4,000 per violation. So you could have maybe 3 or 4 violations in your building. So that could be $12,000 to $16,000 off the top, plus whatever the attorney's fees are. And some attorneys charge $400 an hour. So the attorney themselves have an incentive to take on these sorts of cases, even though the monetary damages for the actual disabled person may be low. Their attorney's fees, if reasonable, can reach in the tens of thousands, which could financially cripple your business. So we'll go into the next slide, which discusses ways that damages may be reduced. So as we discussed earlier in this section of the webinar, if you have a CSP report for your commercial space and you are served a complaint within 120 days of your business being inspected and these violations being found, then if you have this report, the damages will be reduced to $1,000 per instance instead of 4,000, and then you have 60 days. So again, let me clarify. So you get a report, and within 120 days, within that report being drafted by the CASP inspector, someone comes into your business, they see that there's a violation, that violation's on the report. So because you have that report and the complaint was served within 120 days of that report being drafted, the $4,000 amount per incident will be reduced to $1,000 if your website or your site, if you correct those violations within 60 days of being served with that complaint. So although it won't remove the lawsuit, it will significantly reduce the damages, but still it won't reduce the attorney's fees. So that is the issue. The attorney's fees could still be quite significant. So it's important to fix those violations that are within the report as soon as possible. So let's go to the next slide. So for new construction or improvements, liability can also be reduced to $1,000 per offense if you are served. If you are served with a complaint by the moving party within 60 days of the inspection by the CSP inspector. So if you receive this complaint within 60 days of that report, those damages are reduced to $2,000 per offense. Excuse me, let me clarify. If you're a small business owner, oh, I just confused the information. I will go back and clarify. So for new constructions and improvements, if you receive a complaint within 60 days and of the report and you fix it within those 60 days, it's $2,000. If you're a small business owner, the time frame is a little bit different. You have 30 days instead of 60 days, like the new improvement or new construction or alterations to buildings. You have 30 days instead of 60, and those damages will be reduced to 2,000 instead of 4,000 if you fix those violations within 30 days of the complaint. And so to be considered a small business owner, you also have to meet certain requirements, like you have to have less or an average of 25 or fewer employees, and you have an annual gross receipts of less than $5 million for the last 3 years. So for the last 3 years, an average of 25 or less employees, and then you also have to have made less than $5 million for the past 3 years as an aggregate. And that small business, in order to prove that they're eligible, also must file wage report forms showing the number of employees and federal or state tax documents showing the amount of revenue they brought in for the last 3 years. And it has to be lower than the amount that I previously mentioned. Okay, so the next portion, I know that was a lot of information. So if you do have questions, I would suggest you write them down now or put them in the chat and we'll address them at the end. Again, this was a lot of information to take in and we understand that. So part 3 is connecting you, the small business owner, to resources that will assist you with either getting the CASP report, finding representation or assistance with responding to a demand letter or a complaint, and just answering your questions in general. So firstly, we highly recommend that you consult with an attorney regarding your questions about the law, or if you receive a demand letter or complaint, because there are little nuances that you may not know. There are instances where time is of the essence, or there are instances where you may be eligible to receive a reduced liability amount. And so it's highly recommended that you consult with an attorney. And in the state of California, specifically, if you have an LLC, which many of you may have, or a corporation, or an S Corp that's attached to an LLC or a corporation, you cannot represent yourself in court. It's illegal, essentially. You have to get an attorney to represent your LLC or your corporation, even if you are the only individual listed as the owner. The only time where you can represent yourself in court without an attorney under an ADA lawsuit is if you are a sole proprietor. Okay, so next, resources to assist you with your questions, or if you are served a lawsuit. We have the ADA lawsuit itself. As you can see, we have the ADA information line. If you have questions about compliance, there's the ADA network. We have Access Board, Equal Employment Opportunity Commission. There's us, Tzedek, other nonprofit law firms like Public Counsel who may assist you if you're eligible and you do reach out. There's the SBA who also may assist you. And then lastly, we will discuss how to evaluate a claim. And again, because this may be confusing and it's also law-based and statute-based or court case precedent-based, we recommend you reach out to an attorney or an organization that has experience dealing with these sorts of legal matters, because you want to ensure that you respond in the best way that can reduce your damages and maybe waive them in some particular instances, like we discussed under safe harbor. So I don't recommend you evaluating the claim yourself, even though you are able to when you receive a demand letter or a potential complaint via a filed lawsuit. It's recommended that you reach out or hire an expert. And it's highly recommended when you take over a commercial lease space or you're doing alterations or new constructions for a building that's going to be open to the public, that you do receive a CASP report as soon as possible. It could protect you in the future from exorbitant legal fees. So if there is a violation and you're made aware of such violation, we recommend that you take pictures of the violation before any improvements are made, because you may, if it reaches the court stage, then you may be required to show that what the space was before any improvements were made. And so if you don't take pictures prior to doing this, this could affect your court case later. So if there is a violation, again, you want to make sure you take pictures, and if applicable, because you have a CASP report, to complete any not modification, what's the word? If you're going to cure the violation, make sure that you do it within the particular time frame that's allotted to you in order to reduce any liability on your part. Okay? So, and another thing is, if you are able to, we recommend that you attempt to settle, if possible, with the party alleging a violation. Get that settlement in writing, make sure that it's reviewed or drafted by a lawyer, and that it includes all the important clauses and it's signed by both parties, and that you subsequently fix any violations. So that was our presentation. We thank you so much for attending. And now this is the portion where we will open the floor up, even though we're online, to any questions that you may have for Carla and myself. Thank you.
Yes, hi. Thank you so much, Mar. I really appreciate you taking the time to hand that off to me this afternoon. So I do see that we have a couple of writings in the chat. I'm going to stop sharing my screen so that I can go ahead and access these questions. And let's go ahead and see what we have in the chat. Okay, so it looks like we actually had some great pieces of information provided in the chat. So
Okay.
the list of the CASP in California. So I'll go ahead and I'll include that. It's the CASP property inspection link that was provided by our director that's currently on the call. And I just want to go ahead and open up the questions. I will go ahead and translate this call for questions also into Spanish. I know we have some folks on the call who feel comfortable with listening to Spanish but prefer to communicate in Spanish. So I'm going to do that now. Hola, buenas tardes. Gracias por asistir a nuestra llamada. Solo gustaría saber si hay cualquier pregunta que gustaría presentar a la licenciada, a mí o a personas de nuestro equipo sobre la información presentada. Si no, entonces terminaríamos nuestra presentación y le agradeceríamos mucho a todos ustedes por estar con nosotros esta tarde. ¿Hay cualquier pregunta? Okay, perfecto. Okay, so we have no questions. So thank you so much to everyone for attending today. As noted, I will go ahead and share a recording of today's presentation with everyone, and I will go ahead and include those important links, including the CASP in California, the link to the Tzedek website, and the link to the presentation, to access the application for the small business team at Tzedek. Thank you so much for your trust in us and for your time. If you know anyone that may be in need of services for their small business, please go ahead and share these resources with them. We'd be very thankful to do so. Everyone have a great afternoon. Thank you.
Thank you.
Bye.